Good evening. I am Pushpita Chaudhary, editing team member of Legal Law Forum. I welcome you to a new episode of LLF Talks. Legal Law Forum is a forum based at Nagpur, Maharashtra for the purpose of promotion of legal education and awareness. It acts as a platform where the law students pool their experience and effort in order to promote their legal activities and also to encourage young lawyers by helping them bringing every possible source of legal knowledge to them. Legal Law Forum aims to facilitate the imparting of legal knowledge by conducting webinars, quiz competition, and many other events, LLF Talks being one of them. Sir, I will introduce you now. So today we have with us Advocate Jwalitsoneji sir. He is practicing as an advocate in Gujarat High Court in labor law, criminal, civil, arbitration and land matters. He is also a partner in the BK Soneji Associates, which is practicing since last 37 years in labor law and negotiable instruments. Sir is also a member of the Industrial Safety Task Force Committee in Gujarat Chamber of Commerce and Industry. Sir believes that knowledge can be and should be interesting and also believes that dedication and ethics are the key to success and any task is achievable in the association with God. So, sir, shall we begin with the session now?
Yeah, sure.
Sir, so I will take up the first question. Shruti, the first question which I have is, what is meant by the principle of equal rights?
Basically, if we are talking about labor laws, so equal rights will mainly tends toward the interpretation of the wages available given to the workmen, and other equal rights will be the opportunity of hearing to all the workmen. So, if we talk about monetary benefits, then no person should be discriminated on the ground of religious, caste, sex, or any other ground. If a person is doing a job and the similarly situated person is doing the identical job, then he should be properly remunerated according to that job. Now, this needs to be interpreted properly because a person is, if there is a labor, he cannot compare himself with the manager that I am doing more hard work than why he is getting more work. So that is the equal. That's how it deserves to be interpreted properly. Every person should get equal remuneration if they are similarly situated. Now, the opportunity of hearing also should be given to each and every person before terminating them. So, if a worker is there, and this may not be entirely related to equal rights, but I may just share that if a workman is having any grievance, or if an employer is having grievance against workman and he wishes to terminate him, then first he need to give him opportunity of hearing before terminating his service. This is the rights given to the workman so far as current scenario is concerned. This may not be part of the Code of Social Security, but still for the spreading awareness, I may share it.
Okay, sir. And what is the specification of a probation period regarding this?
If we talk about the current 4 new labor codes, the probation can be up to 6 months, which can be extended further up to 3 months. Now, before we do that, there is a need to understand what is exactly the probation is. See, probation can be broadly interpreted in a way that it is given an opportunity to employer to examine the capacity of the workman. See, on the basis of the qualification, anybody will be appointed on a particular post, but it is not possible to judge for an employer to examine whether that particular employee is qualified to sit in my establishment, whether he fits in my culture, whether he can do the job which I have assigned to him. So for that, the time period is given to the employer to judge. And I may even say that it will be injustice to the employer if this opportunity is not given to judge his employee. Otherwise, he will keep paying the wages to the workman and he will not get anything, the satisfactory result. So that's why the provision of probation, I really support it.
Sir, do you believe that this new labor code will reduce the corruption?
See, to understand that, first we need to understand how the corruption works. generally what happens that either a government officer maybe, I'm not saying all government officers are corrupted, but this is only to those who are not honest. So either he may come to your office or you may have to go to the government office for the requirement paperwork or anything, license or anything what. Now, so far as SS code is concerned, a specific provision is there that there has to be inspection, faceless inspection. So that for corruption, if you say that the requirement of physical presence is must, I'm sorry, requirement of physical presence is must, and there has to be transaction is cash. Otherwise, if it is digital, then you can definitely track it. So when you are, it is made more convenient to for inspection which is faceless. It is more made that you can even submit documents electronically. Then that will certainly decrease the chances of correction. I cannot say it will completely wipe out, but that will certainly give an opportunity to reduce the corruption. And this may suppose now suppose if I'm having good repo somewhere, and just hypothetical example that I support corruption and something, if I say that, so if I visit office, then I will be given priorities and those who are not giving that much, I mean they don't have a repo, they will not be given that much priority. Now this provision is made faceless and the data can be transferred electronically, so everything will be given priority as per the date of application. So this will give a huge impact, and I really appreciate the provision made in this section. Yes.
Okay, sir. Okay, so the next question which we have is, sir, talking about the fixed term employment, what are your views on it?
Fixed term employment was there earlier, but there was no, as such, no explicit provision. Now in the new labor code, there has been explicit provision that you can appoint someone on a fixed term, even if the post is permanent or the requirement of the work is permanent. Earlier it was difficult to appoint, but now there is a clear provision in SS code. So this can be even misused. Suppose now in India, if you wish to terminate a workman, you need to conduct, as I mentioned earlier, that you need to conduct departmental inquiry. You need to give him opportunity hearing. Now, as an employee, if I wish to misuse it, though the post is permanent, I will appoint him for a fixed term. Again, then fixed. So for that can be misused. But in the SS code, the positive aspect for the fixed term appointment is that there is an amendment in payment of gratuity. That I'm not saying earlier this was not there, but this is specifically explicitly stated that if a person for a gratuity you need to complete 5 years of service, but if you are appointing someone on a fixed term employment, then he need not to complete 5 years. Even if he is appointed for 1 year, he will be entitled for gratuity. So there is a positive and negative aspect both in so far as the appointment on fixed term employment is concerned.
Okay, so one of our viewers, Tanya Shaha, she is saying that this is an ideal scenario, sir. Workmen do not get opportunity to speak for themselves.
But we are also talking about our view. Government is, see, in parliament also you can see even there are many representations going on between government and the employers association, the workers side. Both are making, of course, in this interview, there is no one present to defend government. Even I am not also criticizing the government. To some extent, even I am supporting, because earlier there used to be more than around 256 provision, which is reduced to 164. So even the process is streamlined to that extent. I mainly am supporting the move of the government, but apart from 2-3 things, I am not.
Okay, sir. So the next question which we have is, what are the major changes in PF provisions? I mean, Provident Fund provisions.
Earlier, see, there are 2-3 main changes. Earlier, if there is an order of PF assessment, suppose an employer committed default in making payment, so there is a PF assessment, there is an inquiry, and there is an order pass. Now let us take an hypothetical example that there is an order of 10 lakhs rupees. So earlier there used to be provision that if an employer wished to challenge the order, then he need to deposit 75% of the original amount. before the authority, PF authority. Now that amount is reduced to 25%. So this is now, see, if we talk about provident fund, it is mandatory for a PF authority to determine who is the beneficiary. In absence of beneficiary, they cannot direct a government that you have the employer that you have defaulted in making this payment. So make this payment as soon as possible with interest, with penalty, whatever. So now now let us analyze the scenario. The award is of 10 lakh rupees. We are hypothetically taking as a bad order that without identifying beneficiary, he has passed an order. So earlier, employer used to deposit 7.5 lakhs rupees as a 70. Of course, that the tribunal was given power to reduce it, but let us take that he is directed to deposit full 75. So that 7.5 lakh will remain unused before authority, though even if the order is illegal and unjust. Now that, so you cannot use the 7.5 lakh till you win the case. You cannot have interest. You cannot use it for industrial growth. Now that amount is reduced to 2.5 as a 25%. So that 5 lakhs rupees of advantage will helpful employer for their industrial growth. So this is really a big amendment that this is big relief to the employer. Earlier, employee state insurance, now this is second major change. Earlier, ESI, there was a limitation that prior to 5 years, you cannot do any estimate. You cannot ask the employer to make the defaulter contribution. Now, in this new code, even the limit is fixed for PF also. That prior to 5 years, you cannot ask employer to make any payment. So that as a relief which was only in ESI, now that is extended for the PF also.
So in a way, the new code is beneficial, right, sir?
I'm sorry, I didn't hear.
In a way, the new labor code is beneficial for the employees, right, sir?
Exactly. Both employer and employees both.
Okay. So since the pandemic, everything has gone online. So, sir, what about the importance of keeping records electronically in this time, or even after the pandemic? Is digitalized?
Yeah. See, keeping the record electronically will save lots of office space here. So, I mean, if you visit the earlier office, there used to be lots of cupboards and all that, which will be full of record. So that is the advantage that each and everyone would know. Now, storing the document is also, not transferring the document is more convenient. WhatsApp, email, and everything. Now, earlier, even for the filing of the government work, we can also keep the record electronic, but there was no explicit provision. Now in this new labor code, without even permission, we don't need any approval of government authority to keep the record electronically. It is employer's right to keep it electronically. And considering the present scenario, the way the world is moving towards technologically, even in high courts also, I mean, during the pandemic, we had hearing via virtual. Earlier, the mobile phone was treated as a villain, that you cannot use phone while the proceedings are going on. You cannot even record. Now everything, so far as Gujarat High Court is concerned, even the proceedings are going online, even if physically hearing is open. So there is a great shift in the way of working. So it is really, I mean, I really support it that government also taken this decision to we allow to store record without any approval.
So, do you think this on-particular hearing of the courts will reduce the number of cases which are pending in our high courts or our Supreme Courts?
Yeah, see, if there won't be virtual hearing, then there will be any number of litigation which will be pending. Of course, if you are present in the court, that increase efficiency, that you wish to submit any document, you can directly submit. Today also, like during virtual hearing also, you can scan and submit it directly, but it is slightly more convenient to during the physical. But I cannot say, I mean, it is incorrect to say that the virtual hearing were inefficient. there is a slight advantage in physical hearing, but virtualing is efficient that much also. Now, I mean, if there could be concept of hybrid hearing, that is also, I mean, that will be also beneficial. Suppose there is someone who is in Mumbai and he wishes to attend hearing in Ahmedabad, then he will have to travel on him or her. That if there is a hybrid, that could be the advantage for someone. And even
Yeah.
like traveling between two courts, that will lots of time will be saved.
Also, if an advocate wants to practice in any other states, then he can do it virtually. He doesn't have to
Yeah,
travel. That
exactly.
is a.
That time will save, lots of time will be saved. But it is a matter of decision by the honorable courts that what to do.
I
And
hope they
support.
take this. This will be a
You, I,
So moving on to the next question. What is the update on time-bound recovery of PF and ESI dues?
yeah, that was just I should mention you that earlier ESI was only that you cannot recover prior to 5 years amount. The assessment, you cannot do any assessment prior to 5 years from the day when matter is referred. Now in this new word, it is extended to PF also. This is what we talk about in the discussion.
Okay, so what are your views on the wages definition of wages?
Earlier, see, be it PF, be it ESI, be it gratuity, all were having their own definition. So that used to create lots of confusion even among the employers or even those who are giving advice to the those who are in the legal field. There was no streamlined definition of wages. Now in this new code, a single definition is there, and it says that basic HRA retention allowance and even the commission to pay the bonus paid, the award of settlement, the 2P settlement, which we say, all the amounts are clubbed and mentioned in the definition of wages. But there is another technical aspect in the definition of wages that so far as PF, ESI, gratuity is concerned, that I cannot in this interview to elaborate the definition, but 50% of your gross salary you need to you need to pay contribution of the 50% of the total gross salary. That is the final outcome. Of course it is debatable. Many representations are also made by the government to the to the employers association, to the government, that please change something like this, because it will create huge financial burden on the industry. It may even reduce take home of the workmen. Now, if we talk about the take home of workmen, it really affects the economy. See, those who are employers will certainly buy products which are luxurious. It is the workmen who will buy the products which are cheap, and many industry may be surviving on that. If the workman's take home is reduced, that will reduce the purchasing power of a poor person. If purchasing power, that will create lots of difficulty to the industry. So this is a debatable issue, but I may think that government may think about it and do the appropriate amendment if it is required.
This will also reduce the burden upon us also.
Yes,
Like
exactly.
for law, we have to read less, and for the
Yes.
advocates, we have
Yeah.
to read less to clients.
See, earlier there used to be 250 section, and now it is reduced to 164. Now, earlier we will have definition number so and so of this act, so and so of this. So there could be, class that okay, wages in this definition in PF code is like at this section, and ESI is for in this section. Now there is a streamline, like they are in single line. So remembering, of course, it is not difficult for a lawyer to remember it, but remembering a particular section is made more convenient by the government.
Okay, sir, moving on to the next question. Sir, what are your views on mandatory linking of Aadhaar, which violate the Supreme Court judgment?
I will not say that it violates, because for the government, if we read the judgment and if I recollect properly, for the benefits of the government, you need to update your Aadhaar card. See, this is a beneficiary legislation, be it PF, be it ESI. These are all scheme of the government, central or state, that is so far as particular facts are concerned. But So if if an employee is trying to take advantage of that, updating Aadhaar card should not be problem, because when you are when you are getting the Aadhaar card, you are giving consent to give all your biometric and relevant details to the government. So in a way that it cannot be said that there is a violation. And so far as present government is concerned, they are really motivating people to get the Aadhaar card. Lots of lots of funds are utilized of taxpayers' money. So and it is mandatory, because other countries may have, but India didn't used to have prior to some years. But now Aadhaar is really mandatory, and I really think that nobody should object to that when you are already given consent to give your details to the government.
Yes, so when we are registering for Aadhaar, we have already given our biometric for
Exactly.
registering.
Exactly.
Yes.
It is not given under compulsion. It is given because we want it.
Also, sir, Aadhaar reduces the burden. Like, sir, from my personal experience, when I was traveling, I didn't have my voter ID card or what will say any other ID proof. So, Aadhaar
PAN
card
card,
was
PAN card or something.
yes, sir, PAN card, but Aadhaar card is acceptable everywhere. Even if PAN card, if you not carrying your PAN card or voter card, Aadhaar card is acceptable.
Yeah.
So, in a way, it's easier to carry.
Exactly.
Also,
Even we can carry it digitally also.
yes, digital is also accepted these days.
Yes.
So we are done with the questions here. I don't have any more questions. You are free to share if you have any, if you want to say something.
I'm sorry. Am I?
We are done with the questions here. Want to share anything
Your
with us?
video
You can.
is not coming properly.
Sir, am I audible now?
Yes.
Sir, we are done with the question answers. I have pretty much covered up every questions which was there. So, sir, if you have anything to share with us, you can.
No. See, as such, I am not having anything, because this is like question and answer session. But this, I'm really, I have personal level. If I talk about, then I have really become fan of this third code, decoding 37 labor codes into 4 labor codes, labor laws into 4 labor codes. That will really streamline many things. That even the administrative process will be more efficient. The work will be reduced. Storing the documents electronically. This inspection, which is made faceless. These are really something key features which government has introduced in this code, and let's hope that as soon as possible these code are implemented in the entire country. What will be the interpretation, how these honorable courts will interpret the law, that is different thing. It is the time which will decide how these all 4 courts will take its proper shape. As so far as we are just reading what is mentioned in the black and white paper, and we are interpreting in as per our opinion, but it will be the court's opinion in a judgment that will be binding to the entire nation, or if we talk about the high court, then entire state. So let us just wait and watch, and let's hope for the best that this attempt be a successful attempt.
I just hope it gets implemented soon.
Yes.
So the book is this much big and have to remember everything. So the new labor code use the burden, a lot of burden.
Yeah. So this will ease out many. Yes.
All right. So it was very nice having you again with us.
Yeah. It was my pleasure to be it again. Thank you. I really have.
Thank you very much. Goodbye. Take care.
Goodbye. Take care. Stay safe.